Hello and welcome. This is Rick Hidalgo. This is Civil Authority Channel, and this is our second episode. Welcome back, everyone. I hope you enjoyed the first episode, which was called Regaining the Gift of Liberty, where we exposed the idea of you becoming the executor or holding the office of executor over the estate that was created specifically for you. And now today, as I promised, we're going to cover some of the ground rules. Now, we're going to call this Exploring the Rules of Evidence. So this is episode 2, Exploring the Rules of Evidence. And on that note, I want to remind everybody that this is not legal advice. I do not provide legal advice. I am not a bar attorney. I'm not certified. I'm not a card member. I'm not any of that stuff. I want nothing to do with the bar. And I'm not interested in legalities. What I'm interested in is law. I want to follow the law. I want to understand the law of nature and of nature's God that it speaks of in the Declaration of Independence as being the basis of our Republican form of government. That's what I want to understand. So when we talk about law, we're not talking about any legal statutory, statutes at large, none of that stuff. We're not talking about any of those things. Everything is up to complete scrutiny at this point. So I'm not here to offer any legal advice. This is all being done absolutely for free, for your education. As I expand my education, I'm going to pass on the things I learned to you. Now today, what we're going to do is there's a great website online called cornelllaw.edu. If you go to law.cornell.edu and you click on the Federal Rules of Civil Procedure and you go to subsection 4, which is on parties, Rule 17 is in subsection 4. We're going to start by looking over Rule 17. Rule 17 is going to tell us it's in the category of plaintiff and defendant, their capacity, and public officers. These are the things that Rule 17 covers. Okay. Now the first thing on Rule 17 is A. It says real party and interest. Now, anytime that you're bringing the law, okay, in to a courtroom setting or to in any setting, all right, handling your business, handling the business of the office of executor, what you're going to want to do is always be the real party and interest. And this is going to specify how to get designated as the real party and interest. And this is what it says. An action must be prosecuted in the name of the real party in interest. The following may sue in their own names without joining the person for whose benefit the action is brought. So they're telling you the following are species of individuals who are allowed to sue, okay, in their own names without bringing it in the name of the real party and interest. Okay. Because these people, persons, as they call it, are actually those who in some fashion represent the beneficiary. Okay, and that is A, an executor, B, an administrator, C, a guardian, D, a bailee, E, a trustee of an expressed trust, F, a party with whom or in whose name a contract has been made for another's benefit, and G, a party authorized by statute. So there's quite a gamut of different species of individuals who are given the opportunity to, as it says, sue in their own names without joining the person for whose benefit the action is brought. Notice that the very top one is executor. Now, these are not in alphabetical order, so you have to assume that the reason that they're in the order that they're in is because the top one is what happens in most cases. It goes from top to bottom. What you're going to find is that the prosecutor, in most of the cases, if not all the cases that come across the docket, is actually acting as the executor of the estate. And the judge is acting as a trustee of the estate, trying to keep the executor within the confines of the law in which he's defined. Because remember, the executor brings the law. Okay? The appropriate law. That's what the executor does. The executor brings the appropriate law. So if your estate is a domestic estate within the U.S., not without the U.S., but within the U.S., what happens is you are defined as under the jurisdiction of the U.S. Now, it goes on to explain this. In section B, in section B it says this: capacity to sue or be sued. Capacity to sue or be sued is determined as follows. Now listen very carefully to the formatting of these. Number one, for an individual who is not acting in a representative capacity. They're telling you what law that person is going to be judged under. An individual who is not acting in a representative capacity. Is that an executor? The answer is no. That's not an executor, because executor is acting in a representative fashion to the estate. So if the individual is not acting as a representative in a representative capacity, then by the law of the individual's domicile, that would be his jurisdiction. The individual's domicile, so where he lives, is his jurisdiction. Second, for a corporation, by the law under which it was organized. So if it's a corporation, their capacity to sue or be sued is recognized under the jurisdiction in which it was registered or filed. Where was the business organized? That is the corporation's jurisdiction. Number three, for all other parties, by the law of the state where the court is located. Except that of a couple examples which are very rare. But three, for all other parties by the law of the state where the court is located. Now this gets very complicated, because when you look up the word state, the word state is referring to the territories of the United States. When you look up United States, the term in the in these civil rules of procedure, the term United States is also referring to the territories of the United States and the jurisdiction thereof. Now this is where it gets a little bit complicated, because when you think of U.S. and you think of the word states, you're thinking of one of the 50 states in Union, the Republic. But that is actually not the definition that they are using in this law. You would have to go look that up in the definition section of this law. But that is the case. This is where we get very confused, because a U.S. citizen is a domestic citizen to the territorial expression of the federal government. In other words, the federal government has unlimited jurisdiction over the territories. They can make any law over the territories. There is nothing stopping them from doing so. But the states have constitutions that are applicable to the states, and they can only go as far as the Constitution allows them to go. So as U.S. citizens, you're a territorial citizen, and you have no constitutional protections. Zero. None. No constitutional protections. This is part of the fraud that's going on, is in the definitions. They were never given authority to redefine definitions that were used in the Constitution. But they did. And the 14th Amendment is part of what was responsible for that. In the 14th Amendment, when the emancipation happened and all of the Negroes were freed, they all became naturalized as United States citizens. It actually says citizens of the United States with a small c. Before that time, it had always been citizens of the states. People were capital C, citizens of the states, and were by default capital C citizens of the United States of America. Very clear distinction in the way that you grammatically apply the word citizen and the term United States. Tricky, yes, but these are facts that need to be known before you begin to understand the jurisdiction issue in the court. So, I need to go back to Rule 17 for a second and explain to you that they gave no condition when it came to capacity to sue or be sued when it pertained to a represented capacity. Okay, when it came to someone who was represented, an individual who is represented, what is his capacity to sue or be sued? What law are they established underneath? There is no designation here. No designation. Therefore, because there's no designation in B, it goes back to A. That is the eye test, if you will, to find out whether you are a real party in interest. If you are a real party in interest, an executor, administrator, guardian, bailee, trustee of an express trust, party with whom or in whom a contract has been made for another's benefit, or a party authorized by statute. If you're any of these things, you are a real party in interest, and you must bring the law. This is why they have specifically set up the court system the way they have, where every county has a state's attorney. And in that county, the state's attorney is the one that brings the law. Guess what law they're beholden to bring in? statutory law. That's what they bring forward, is statutory law. Why? Because he's acting as an executor. And in his executor office, because the real true executor hasn't come forth, so this is called an executor de tort. I believe that's the French word for it, which means a false executor. Until you come forward as the executor, he stands and he brings forward the law that he chooses to bring forth. Until you stand up and decide to bring forward the law that you choose to bring forward. And it's going to get a little bit edgy here when I begin to explain to you that what you're going to bring in is actually foreign law to the United States. Because remember, we're talking about the United States territorial application. So when you're talking about a territorial application, the states are foreign. The state constitutions are foreign to that. Okay? So we're going to bring in, as executors, the law of the state in which we were birthed. Because that's where the estate was created. And we as executors must enforce the law. Okay? So I hope I explained Rule 17 well enough. You can listen to this over and over and over again until it clicks. Okay? Now I want to go to Rule 44. Rule 44 is very important because the title of it is Proving an Official Record. This is going to tell you how to prove an official record. You see, you can't just write things down or an affidavit, get it notarized and take it to court and expect that they're going to listen to anything that's on it. It cannot be admitted as evidence in a court. Why? Because there are rules as to how you can prove an official record. And that's what I want to bring forward to you today. Is one of the mistakes that we've been making is we have not been fully authenticating the records that we bring into court, and we haven't been walking in the right office. We have to first resume the office, and second, bring the law. And when we bring it, it has to be authenticated. Let me read this to you. Means of proving. 1. Domestic record. Remember what the word domestic means. Within the United States. Territorial application again. Each of the following evidences an official record or an entry in it that is otherwise admissible and is kept within the United States, any state, district, or commonwealth, or any territories subject to the administrative or judicial jurisdiction of the United States. Now, a lot of people are going to be confused. They're going to say, well, why does it mention state and territory? You know, unless both apply. Well, here's the problem. If you're going to extend a rule to a territory in which the United States has supreme jurisdiction and they can create any rule that they want to, okay, you can't extend the same to a state where the state is under an obligation of a constitution and they have to be very specific to that constitution. So when they say state here and include the word or territory subject to the administrative or judicial jurisdiction of the United States, they're contriving, they're creating, they're falsifying the record so that you are confused and so that you think that this applies to the states. Remember, the word domestic is specifically talking about territorial records. So how do you prove it? An official publication of the record or a copy attested by the officer with legal custody of record or by the officer's deputy and accompanied by a certificate that the officer has custody. The certificate must be made under seal. if you are going to bring in any evidence that is within the territorial or domestic record jurisdiction, you are going to have to bring it in under seal. And there is but one way to get a record brought in under seal uh, in a foreign way. And I know that sounds very confusing, but I want to explain. When you go, when you write out an affidavit and you get it notarized, okay, you can send that document to the Secretary of State's office and you can have them authenticate that document. What's going to happen is they're going to ask you some questions. First thing they're going to say is, for what country do you wish to have this document authenticated? If it is one of the countries where we have a treaty, if it's a Hague country, and I think there's 70 something of them, then they're going to offer you what's called an apostille. They're going to place a seal of the United States jurisdiction, the territorial jurisdiction, and that record is going to apply in a territorial with a territorial application. It's going to prove that you are within the U.S. You are a U.S. citizen. You're acting within the capacity of a U.S. citizen, and that is not where you want to be. However, if you get it authenticated for a non-Hague country, and you can look up which countries are Hague countries and non-Hague countries. The Hague is a big international court. Okay, if you get it done for a non-Hague country, this is called authentication. And if you get it authenticated, it's going to come under the seal of the state, the Secretary of State's office, and it becomes a foreign document, foreign to the United States territories. Okay, territorial application. So this is how you get something under seal. You bring it in as record, as an official record. It also says you could do it by a judge of a court of record in the district or a political subdivision where the record is kept. And by the way, that term, political subdivisions, actually means subdivisions of the corporation United States all the way down to your municipal city. Go look it up. By a judge of a court of record in the district or political subdivision where the record is kept, or by any public officer with a seal of office and with official duties in the district or a political subdivision where the record is kept. Now this is a domestic record. This is how you get domestic records. So an apostille would be the way that you get a certificate under seal. Any record that you get is going to be apostilled if you say that you're doing it within the United States. But number two is a foreign record. So how do we get a foreign record recognized in the court? In general, I'm reading here, each of the following evidences a foreign official record or an entry in it that is otherwise admissible. 1. An official publication of the record. Okay, an official publication of record. What does that mean? That means go to the Library of Congress, where they keep official records, or the government printing office, and go and purchase an official publication. That's one way. Number 2, the record or a copy that is attested by an authorized person and is accompanied either by a final certification of genuineness or by a certification under a treaty or convention to which the United States and the country where the record is located are parties. Okay? Or B, final certification of genuineness. A final certification must certify the genuineness of the signature and official position of the attester or of any foreign official whose certificate of genuineness relates to the attestation, or as in a chain of certificates of genuineness relating to the attestation. A final certification may be made by the Secretary of a United States Embassy or Legation, by a Consul General, Vice Consul, Consular Agent of the United States, or by a diplomatic or consular official of the foreign country assigned or accredited to the United States. But I take you back to number 2 under foreign record. The record or a copy that is attested by an authorized person and is accompanied either by a final certification of genuineness or by a certification under a treaty or a convention to which the United States and the country where the record is located are parties. Now, how do you make a foreign country party to the United States? Through authentication. Or, if it's going to be through The Hague, as one of the Hague countries, then through apostille. But this is how you bring in a foreign record into the court. So it is very important, very, very important, that we authenticate everything that we bring in. Also, there is C, other means of proof. If all parties have had a reasonable opportunity to investigate a foreign record's authenticity and accuracy, the court may, for good cause, either admit an attested copy without final certification or permit the record to be evidenced by an attested summary with or without a final certification. So, you're taking a chance of not getting it brought into evidence if you don't have it authenticated, because then they must. And even more so to the executor, who's going to step up and take the bull by the horns and say, I'm back. Here I am. I'm here to run my estate. I'm here to bring the law. And that's exactly what you're going to do. You're going to walk in and you're going to bring the law. You need everything authenticated. Everything. If you're going to bring a case in from the territorial jurisdiction of the Supreme Court to prove something that you are attesting to, you better get it authenticated. Anything and everything that you get authenticated. File it, and then use certified copies of that filing to serve notice upon the court and the officers of the court. I also wanted to bring up one other thing that was quite interesting, and I didn't run into this until today. But Rule 44 has a point 1, determining foreign law. Now listen to this very closely. A party who intends to raise an issue about a foreign country's law must give notice by a pleading or other writing in determining foreign law. The court may consider any relevant material or source, including testimony, whether or not submitted by a party or admissible under the federal rules of evidence. The court's determination must be treated as a ruling on a question of law. Did you hear what it just said? You must issue a writing concerning the foreign country's law that you are bringing in for determination of law. You are asking for a question of law. This is very significant, very important for us to remember. That is Rule 44.1, determining foreign law. Now, I bring all this to you today because I want you guys to begin to put the pieces of the puzzle together and understand what you're going to have to do if you want to operate within your liberties, your God-given, inherent liberties. If you want to function within those liberties, these are things we're going to have to be prepared to do. So, I think that's enough for today. I'm not going to go any further. I'm just going to quickly remind everybody this is not legal advice. Don't take my advice as legal. It's not. I'm just telling you. I read it right off the page. This is for educational purposes. And I want you to all understand it's right there in black and white. All we have to do is open our eyes and see it. God bless America. God bless you. See you next time. In Jesus' name. Goodbye.